Hey, what's up guys? We're doing this video outside today because, well, you can't always do it outside because winter is coming. And no one knows that more acutely right now than the New York Times. Yes, that's right. Today we're talking about Project Veritas and their lawsuit against the New York Times. And today, the New York Times took a major loss from the court. So let's get into it. Let's talk about the issues. Let's talk about what was at stake, why they lost, and what is coming next. This is actually very big news for Project Veritas and very bad news for the New York Times. All right. I'm Nick Rekieta of Rekieta Law, a small law firm in central Minnesota. I'm a lawyer. I'm also a legal and political commentator on YouTube and on Odyssey. Wherever you're watching, make sure you hit that like button, hit subscribe, turn on your notifications, all of that stuff. I wouldn't want you to miss any videos. All right. So we are talking about New York Times versus Project Veritas. Project Veritas brought this lawsuit as a defamation action against New York Times. They said that they were defamed when they covered vote harvesting that was going on in Minneapolis. And it's pretty hard to argue that anything other than ballot harvesting was happening. It was caught on video, and the video was actually put up by the people doing the harvesting. There was not much really to refute what was going on. However, the New York Times took it upon themselves to have a couple of their published pieces about this state that Project Veritas was engaged in an active disinformation campaign, and that disinformation campaign was, putting out a false narrative about ballot harvesting. So that is the source of the defamation action from Veritas against the New York Times. Now, New York Times tried to employ New York's new anti-SLAPP statute. New York has actually had an anti-SLAPP statute for decades, but they tried to claim that recent revisions to this statute made it into a new thing, and they have claimed that there were new aspects of law and all of this stuff. They're really kind of trying to oversell it, but that's okay. An anti-SLAPP statute is a SLAPP is called a strategic lawsuit against public participation, SLAPP, right? So that's a SLAPP statute. So they're alleging that Project Veritas is using their this lawsuit to prevent the New York Times from participating in public discourse about matters of public concern, which is a little silly to suggest that someone has the power to stop the New York Times from publishing an article by merely suing them in court. But that is the claim that they are going with. And so when you have one of these SLAPP statutes, you file an anti-SLAPP motion to dismiss. If you win on that, you win the case. You win it outright, and you win it early. And this was what the New York Times tried to do. Win the case right away, saying this lawsuit is meritless. It doesn't have any purpose other than to basically prevent our free speech. Now, they lost that. I talked about in a video when they did lose it. And then what they've done since is they have appealed the loss of that decision. And the problem, though, is that once they lost, the lawsuit resumes. Whether or not their appeal goes through is a different matter. The lawsuit itself underlying this whole thing gets to move forward. And so immediately, Project Veritas moved to depose some of the journalists from the New York Times. A deposition is where you get someone under oath and they have to answer all of the questions you ask them, really without many exceptions. So Project Veritas wants to depose and put under oath some of these employees of the New York Times, ask them questions, put them on camera, and make them state what was going on, right? Like, that is the goal. That's what they're trying to do. New York Times filed a motion, and this is what we're talking about today. Sorry for the backstory, but we got to be clear on where we are. They filed a motion to stay the discovery, okay? So they're asking the court to say, wait, while we've got this appeal going, we want you to stop any efforts that Project Veritas has to do anything else in this case. Namely, we don't want to do discovery. New York Times is very, very scared of discovery in a civil matter. And most news organizations are, especially in this politically charged climate. If you've got emails at the New York Times talking about how they view conservatives, maybe, that might look kind of bad for them if that were to come out publicly. If you were to talk about how maybe they gear their news towards a particular political end, I mean, that might make them look a little bit less objective. Now, I don't think a lot of people are under the illusion that the New York Times is anything other than partisan, but some people might still hold on to that. So they want to avoid this at all costs. And they think maybe if they win their appeal on the AntiSlap, or they think definitely if they win their appeal on the AntiSlap, they won't have to have that discovery. They won't have to go through it. And that's what they want the court to say here, is say, no, you don't have to do the discovery. You don't have to do depositions. And their argument is that, well, it's really expensive to do discovery. In fact, that's kind of the genesis of the AntiSlap statutes, is you could sue someone who is engaged in potentially negative commentary about you, and then it would be really expensive for them to have to go through this lawsuit. So if you had a bunch of money and maybe they didn't, you could drain their resources as punishment. Whether or not you lost the underlying suit, it didn't really matter because you punished them financially through the courts instead. And so New York Times is saying, hey, look, the AntiSlap statute was created to prevent this discovery, the cost of discovery in litigation being used as a weapon against a party. And so we think discovery should be stayed. Well, the court disagrees with that. The court disagrees with that because their AntiSlap motion isn't actually about the discovery fees. At least that's not what they alleged. They said the underlying action is frivolous, right? That these are meritless claims, that they have protected speech, and that was shown at the AntiSlap thing. But they lost on that motion. So the judge actually says, no. You didn't file an AntiSlap because of discovery. You filed an AntiSlap to dismiss the entire case. Right? Because that's what the purpose of the AntiSlap is. While there is an ancillary benefit that you might stay discovery or avoid discovery if you win on an AntiSlap, that's not why the legislature actually fully passed it. It was to outright dismiss meritless lawsuits, not to provide temporary relief from discovery during a lawsuit. It was the overall cost of litigation and the length of time that it took to resolve these things and all of that stuff that went into the AntiSlap. So the discovery stay is just one portion of it, but it's not actually the purpose of it. And that became kind of a big issue in today's decision. But today's decision, maybe I should just be very clear. New York Times has to go to discovery with Project Veritas. The judge refused New York Times' request to stay the action pending the outcome of the appeal. So now discovery will commence, right? Veritas gets to send interrogatories, requests for admissions. They get to depose people. They get to proceed as long as this action is still going. Now, it is possible, although very unlikely, that the New York Times would be able to get the appellate court in New York to rule in the alternative and overturn the lower court decision and dismiss the case. That is possible. But until that happens, this thing is in full gear. And the funny part of that, a little bit of egg on face of the New York Times, is they argued that there would be no damage to Project Veritas because they're asking for just a very short delay while the appeals court gets around to rendering its decision. But the appeals court is not going to be an actually very short delay. We're going to talk about several months of decision-making time, most likely, going into this. So all during that time, they're going to have to do discovery. And it's funny to me because you say, oh, well, we're just asking for a state of discovery for a very short time while the appeals court makes their decision. But they know it's not going to be short. If it was going to be short, they could just hold off on complying with discovery within the time frame that they have, and the appeals court would, in theory, in a very expeditious manner, render their decision and throw out the suit. But that's not actually going to happen, and New York Times knows it. For what it's worth, Project Veritas made very good arguments in their brief. They basically said, hey, justice delayed is justice denied. So the longer that it takes us to resolve this thing, that's denying us justice. And that's an axiom of the New York State courts. So they said by denying us justice, you are actually, even temporarily, you're doing injustice. So the New York Times had a much higher burden to overcome. They had to overcome this sort of idea of justice delayed being justice denied. The other part that they argued was that the statute itself does not allow for a stay of discovery. The New York Times tried to make out that, again, that this statute was new and refreshed, and therefore the courts had to determine this. But the legislature didn't put anything about a discovery stay in the statute, so or pending an appeal at least, that once it was, in fact, there's language that says once the motion to dismiss is denied, then the whole case resumes in full and discovery is in full effect. So they actually have kind of the opposite wording from what New York Times wanted baked into the statute itself. That's what Project Veritas pointed out. And Veritas also pointed out, rightly so, that part of the relief that they're seeking is a retraction and a removal of the defamatory stories. And they say that, delaying this decision even further, because if you stay the discovery, and then let's say New York Times loses on the appeal and it goes back to the case again, well, then they start discovery. That just kicks the clock further and further down the road. And every single minute that these articles are up and unretracted, something the New York Times could mitigate if they want to, but they choose not to. Every single minute that they're up there, they're continuing to do damage to the reputation of Project Veritas. So with all of that combined, the judge says, nope, Project Veritas wins completely on this. The judge read his own decision and determined that he was correct the first time, that the New York Times did in fact lose their anti-SLAPP motion, and that now they have to comply with discovery. Now, the appeals court could come in with a ruling at some point and dismiss the case. And if they do that, the case is over. But I don't think it's as sure of a deal as New York Times is trying to make it out. And it seems like Project Veritas has cleared a very large hurdle. So in summary, in short, Project Veritas wins yet again on this issue, and we will continue watching as it develops. All right, guys, thanks for hanging out with me today. We'll talk to you soon. Make sure you drop a comment down in the comment section and let me know what you think. And hey, if you like this video, share it around. It really helps when you share this stuff outside of YouTube, on other social media. It helps people like me. So thanks a bunch for watching. We'll catch you next time. Peace. Peace.